Welcome. This is another 5 Minutes with Eric, EPGD Business Law. I'm here in Miami, Florida. And here's a really interesting question. When you're writing a will or doing an estate plan and doing a trust, there's a really funny side story. We just had a guy who was like, I don't want an estate plan, I want a trust. And I was like, that's so funny because it's probably the same thing in your mind. So when you're doing these things, the question often becomes, and I have kids, should I make the same person in charge of raising the kids, the guardian, as the same person who's going to manage the money? So let's just paint a picture. We've got a husband and wife. They're in their early 40s. They have an 11-year-old and a 4-year-old. And the question becomes, if something happens to both of us, if we go to the family picnic and both eat the same potato salad, or the plane crash happens, or whatever it is, if something happens to both of us, who's going to raise our kids? And, knowingly, the parents look at each other and they've already had this conversation. And they both say simultaneously, her sister, my sister, whatever. So they both say it at the same time, and they've already discussed this. And so I said, well, do you have that in writing anywhere? And they go, no. I go, listen, you need to put that in writing. Now, the normal places we put that in writing would be in a will. We can also do a special document called a designation of pre-need guardian for children. And so remember, children become adults at age 18 in the eyes of the law, which we all know is ridiculous. But basically, we want it in writing somewhere because heaven forbid, we've all agreed that the sister's going to take care of our kids and then the husband's family disagrees. So we're in this tragic situation, we're scrambling, we got to figure out how we're going to take care of these two innocent children who just lost both their parents, and now we've got the families fighting. The brother wants it on this side, the sister wants it on this side. So what's the solution? It's pretty easy. Let's write it down. Let's write it down. Let's have a notary, 2 witnesses. I like to do it in blue ink. You will not find a black ink pen in our office because that way we know it's original. And so we're going to write it down. Now, then the follow-up question is, okay, do we want the same person to manage the money? That's a really interesting question because most of the time the answer is yes. Like most of the time is yes, I trust this person to raise my children and I trust them with the money. But let me tell you what could happen. It could happen that they could dip into that money for some personal needs. Maybe they had a big credit card bill one month and they're like, oh, well, we'll pay back the guardianship. And so essentially they're using their power as the guardian of these minor children and they're going to pay a personal expense. But don't worry, it's an IOU. And then maybe they never pay it back. Or maybe even worse, they decide, you know what? Driving a Toyota Corolla is fine, but now I've got these 2 extra kids. I need to buy a G-Wagon. Well, I don't know if you guys know how much a G-Wagon costs. That's a Mercedes, like the big boxy SUV. It's over 6 figures. So, or maybe, our modest house in the suburbs is no longer good enough now that I have to raise these kids. Now I need a mansion in Coco Plum. So these are questions that might come up because they have the purse strings. So the solution, if there is one, is to separate the responsibilities from raising the children to managing the money. Now what we would do if we did a full estate plan is the money would be managed by the trustee of your trust. The children would be raised by the guardian. And we would give instructions to the trustee with regards to the money. We would also give him or her discretion, meaning that they would be able to use their best senses. So my old boss, Jeff Katz, used to say, we want your kids to see Paris, France, not Paris Hilton. And his joke was that if you have a child that is being raised under this trust and this guardianship and they want to go study in Paris for the summer, okay, that seems like a reasonable educational expense. And then you have another child who maybe is a little more wild and they want to go party in Paris for the summer. You say, well, no, that's not how our parents would want you to be raised, and that's not how the parents gave us instructions. So typically we leave instructions for the health, education, support, and maintenance. Those are the discretionary standards that we give to the trustee. And so you can imagine that the guardian is raising the children and the guardian calls the trustee and says, hey, we need a little extra money for school tuition. Okay, that seems like a valid expense. And by the way, I'd like to upgrade my Toyota Corolla to a G-Wagon. The trustee can, within their discretion, say, no, that's not a good use of the money. So kind of the moral of the story is you got to think hard about who we want in these different roles. I often have the situation where the parents say, well, our one child is a doctor, so we obviously want this person to take care of us and the healthcare issues and these things, but they're not really good with money. Our other child is a financial advisor. So it makes sense. You divide up the responsibilities to the person who fits the best roles. In any case, a lot of things to think about. Obviously, it's an uncomfortable conversation. We say that people only usually do this once or twice or maybe 3 times in their whole lives. So for these people, they were early 40s. That's the first time. Maybe once the kids go to college and they downsize from the big house to the condo, that's the second time. And then maybe when they start planning their legacy and their inheritance in their 60s, 70s, or 80s, that might maybe be the third time. So for all of you out there, this is Eric coming at you from EPGD Land. Thank you once again.